Okay. Hello, folks. Happy Wednesday. Yes. I'm Joshua Gonzalez. I am Abundant Housing LA's education director, and you are joining us for Applying the Builder's Remedy tonight. Yeah. So before we get started, because we talk about housing at Abundant Housing LA, we have to do a land acknowledgement. And so I do a land acknowledgement. I think most people in Los Angeles will get the same sort of results. But if you go to native-land.ca, you can put in your zip code and find out sort of like what lands that you're on, right? And I'll put that in the chat in case anyone wants to check that out. Um, so I would say that to say that I put in my zip code, which is 90006. I live in the Pico Union neighborhood. So our land acknowledgement goes like this. So Abundant Housing LA recognizes and acknowledges the first people of this ancestral and unceded territory. It belonged to the Tongva people of the Gabrielino tribe, and the land is now occupied by State Senate District 26 and City Council District 1. Just to be clear, I am seriously right on the border of CD1. So I almost am not in CD1, but I'm there. We acknowledge and honor Indigenous folks, elders, past and present, and their descendants. We recognize that the Tongva peoples are still here, and we are committed to lifting up their stories, culture, and community. Such as the first peoples of this nation ensured every member of the community had a home, and so we share a fundamental human responsibility to ensure that as people who came after, we can say the same, right? So, what does Abundant Housing LA do? Our mission is to address the upstream causes of the housing crisis and housing shortage and build a movement for structural change so that LA becomes a place of abundant housing, right? So abundant housing is a concept, right? It's not just like the first part of our organization's name. Um, but why is abundant housing important? Well, there's a couple of different reasons. Abundant housing is important because more affordable housing. Multifamily apartment buildings are cheaper per unit than single family homes. But even though so many people need a place to live, most of LA is still zoned for housing scarcity through low density suburban sprawl. It also is important for addressing racial and economic inequality. White supremacy created exclusionary single family zoning and then sold it to the public as the American dream. And more housing density actually means more diversity and neighbors, which is a good thing. So we seek to achieve abundant housing through advocacy, policy, and education to shift LA culture around housing. And we hope that y'all be a part of that effort. So, what are we doing here tonight? We're doing applying the builder's remedy, right? If you know anything about housing, you know that, and maybe you don't, but we're going to tell you that sometimes it's really difficult to get housing built in Los Angeles County and maybe all other places too, up and down California. But it's really difficult to get things built. And fortunately, there are a couple ways to do things and streamline the process. So it's like, haha, you can't stop us. And I think that this is one of the ways that we can do that. And here to talk to us about this today, we have Ken Stahl. Thank you so much, Ken, for being here again. He actually did the presentation for us in January in person, and we had a lot of hybrid issues. And so graciously, he offered to come do the presentation again, so that way more people can see it, and so that way we don't have to deal with the hybrid tech issues that we were having before. So Ken, would you like to introduce yourself and get started?
Absolutely. Thanks so much, Josh. It's a pleasure to be here. I'm a big fan of Abundant Housing, obviously, and the mission of the organization. And so thrilled to have the chance to give this presentation again. Yeah, as Josh mentioned, this is an encore presentation of a presentation I gave to Abundant Housing in January. I've also given different versions of this presentation to other organizations like People for Housing Orange County. But this will be a little bit updated where necessary. I might throw in some of the things I've learned and some of the more recent developments, as I'll explain. This is kind of an evolving area. So there's a lot of interesting questions, some of which are still to be answered and some of which are developing right before our eyes. So that's going to be really, really interesting to watch. Sorry about the dog. I'm very excitable and hyperactive dog. So yeah, I'm excited to talk about the builder's remedy with you. And just to, again, touch on what Josh had mentioned earlier, the builder's remedy is one of several laws that have either been enacted or strengthened in the last several years to try to address some of the severe regulatory constraints that California housing faces. As you all know, zoning regulations in California are among the strictest in the country. And so the state has taken it upon itself to try to loosen some of those constraints in a number of different ways, some of which are extremely complex. And so we're going to talk about one of those tonight, one that's been in the news for at least the last 6 months or so, which is this thing called the builder's remedy. So I'm going to tell you all about the builder's remedy, pros and cons, some of the ins and outs, as much as I can, without going into it in a sort of mind-numbing amount of depth about this stuff. But I'm happy to answer your questions afterwards if you want to go into more depth. But first, I'll tell you a little bit about myself so you can understand my sort of background and knowledge about the builder's remedy. My full-time job is I'm a professor at Chapman University in Orange, California, where I run the law school's program in land use, real estate, and environmental law. I'm also a practicing land use attorney with the firm Miller, Starr & Regalia. And in my practice capacity, I've dealt extensively with several of these new state housing laws I've mentioned, specifically the Housing Accountability Act, or HAA. The builder's remedy is a piece of the HAA, as I'm going to describe. So I've been involved in dealing with the HAA, both in trying to assist developers as well as housing organizations get entitlements, that is, to get projects approved by cities and counties, but also where the counties and cities aren't particularly cooperative, it's sometimes necessary to litigate. And so I've handled that as well on behalf, again, of both developers and housing organizations, including several of the YIMBY, or Yes in My Backyard organizations that many of you are familiar with. So that's just to give you a bit of a sense of my knowledge in this area. I'm going to start at the end and tell you what the kind of major takeaways are from the presentation. And here it is. Many cities in Los Angeles County and throughout the state are out of compliance with state housing law, as I'll describe in a moment. And that means they face this potential penalty that's kind of colloquially known as the builder's remedy. What the builder's remedy means is that jurisdictions that are subject to it potentially must approve any proposed housing development project with at least 20% lower income or 100% moderate income housing on almost any site, and here's the key part, regardless of the locality's general plan and zoning standards. So to the extent that we're all concerned about local governments having overly restrictive land use regulations, the builder's remedy is a potential tool for circumventing some of those overly restrictive regulations. There's a great opportunity there, I think, for those who have an appetite for a little bit of uncertainty, but it does present some risks, as I'll discuss. So again, those are the main takeaways. Folks should feel free, by the way, to throw questions in the chat, I'll probably won't be able to answer questions from the chat right during the presentation, but certainly get to them at the end. Want to give just an important caveat at the beginning. For those who were reviewing the slideshow without the benefit of this presentation, this is just a summary. Oh, and by the way, I think, Josh, we did this before, and hopefully we can do it again. We can make this slideshow and possibly the video of the presentation available for folks after, so you wouldn't have to feel like you have to, transcribe everything that you're hearing or taking pictures or screenshots of what you're seeing. And of course, anybody, I'm going to put my contact information up too. So if anybody wants the slides or a video of the presentation, I'm happy to provide that too. Again, don't feel like you have to transcribe everything. As you're going to see, everything I'm talking about is complex. So I definitely recommend that you consult with a land use attorney before pursuing a builder's remedy project, because there's you'll see a lot of ins and outs to it. Okay, and here's kind of the agenda of the way I'm going to go through everything. And then let's start with the builder's remedy basics, right? What is the builder's remedy? All right, so I have to give a little bit of background here. Every local jurisdiction in the state is required to have what's called a housing element in its general plan that accommodates its fair share of the regional housing need. That's an unbelievably complicated process. So I'm not going to get into all that. This is really all that's necessary to know. But again, happy to answer any more specific questions. This housing element has to be updated by every jurisdiction every 8 years. And then it's submitted to the state's Department of Housing and Community Development, or HCD, for HCD's approval. To date, most jurisdictions in the county and elsewhere in the state, it said Southern California here, but this probably needs to be updated. Throughout the state, the first time I gave this presentation, Northern California had not yet had its deadline to have a compliant housing element. Now, most of the Bay Area, their deadline has passed, and they are also mostly out of compliance. There's a few areas, I think Monterey and a couple of other areas that still have their deadline pending, but most cities in the state do not currently have compliant housing elements according to HCD. And it is that lack of compliance that can trigger the builder's remedy. So that's the important background. Now, what I just said was what triggers the builder's remedy is if a jurisdiction does not have a compliant housing element. So this is a very important chart right here. On HCD's website, and you can see the link at the bottom of this page, HCD actually has a report on every jurisdiction in the state's compliance status. You can see that here in this very last column that I've circled in red. And it will tell you if that jurisdiction is in compliance or out of compliance. Those jurisdictions that are out of compliance are potentially subject to the builder's remedy. So if you're thinking about this, one of the first things you're going to want to do is consult this webpage and see if a jurisdiction that you're interested in potentially pursuing the builder's remedy, see if it is out of compliance. By the way, this is a screenshot, so it's not updated to the minute. You would probably, again, want to check that link to make sure that you have sort of the live data on which jurisdictions are in compliance and which are out. Okay, so now you see a sense of how you find out what jurisdictions are in compliance, what jurisdictions are out. Now, let me talk a little bit about some of the legal jargon. I don't usually like to talk in legal jargon, but I think a little bit of it is going to be helpful here. So the builder's remedy is a name that's given to, as I said, a part of a bigger statute called the Housing Accountability Act, a very powerful law that's been made more powerful in recent years. And the key part of the builder's remedy is located, as you can see in this slide, hopefully, at Government Code Section 65589.5D. And I know, I don't, again, normally would not sit here and read you language from the statute, but I think we're going to find this to be helpful. So it says here that a local agency shall not disapprove a housing development project with at least 20% lower income or 100% moderate income housing. Oh, and just as a note here, the law defines lower income housing for these purposes as 60% area median income, and moderate income housing is defined as 100% area median income. Local agency shall not disapprove a housing development project with at least 20% lower income or 100% moderate income housing, or condition the approval in a manner that makes the housing project infeasible, unless it makes written findings based upon a preponderance of the evidence in the record as to one of the following. Now, the language I've underlined here is important: preponderance of the evidence. This is, again, a little bit of legal jargon. Normally, local governments, when they make land use decisions, are given a great deal of deference by the courts. They're subjected to a very minimal, very deferential standard of review. Preponderance of the evidence is a higher standard of evidence than the courts normally require from local governments. So what this means is that the legislature has told the courts, we want you to apply a stricter standard to local governments when they deny housing projects under these circumstances. Specifically, preponderance of the evidence means that the local government has to prove one of these following conditions exists more likely than not. It is more likely than not that one of these following 5 conditions is met. So the law is important because it shifts the burden of proof to cities. instead of giving them the great deal of deference that they're traditionally accustomed to. Now, after that opening language, the law then has 5 conditions under which the city can deny a project that has 20% lower income or 100% moderate income housing, if it can meet this preponderance standard. 4 of them are relatively narrow. We're going to focus here on the 5th one, because this is the one that's commonly referred to as the builder's remedy. In this case, number 5, the jurisdiction can deny the project or condition it in a manner that renders it infeasible if the jurisdiction shows, more likely than not, that the housing development project is inconsistent with both the jurisdiction zoning ordinance and general plan land use designation. And here's the key quoted language, the jurisdiction has adopted a revised housing element in essential compliance with the requirements of state law. So what this is saying is that if a jurisdiction wants to deny a project with 20% lower income or 100% moderate income housing, the jurisdiction must show 2 things. First, that the project is inconsistent with the jurisdiction's general plan and zoning standards. And second, that the jurisdiction has a substantially compliant housing element. If it fails either of those 2, then it cannot deny the project. So what that means for our purposes, and this is the so-called builder's remedy, is that if the jurisdiction's housing element is not substantially compliant, then it cannot deny the project, even if the project is inconsistent with the general plan and zoning, right? That's the kind of power of the builder's remedy. So here's the summary of what I just said, right? Subject to narrow exceptions, if the jurisdiction does not have a substantially compliant housing element, deny a housing project with 20% lower income or 100% moderate income, or condition the project in a manner that renders the project infeasible, even if the project is inconsistent with the development standards in the general plan and the zoning ordinance. That's what the builder's remedy law says. Okay, so that's right in a quick nutshell what the law right on its face says. Okay, so next, suppose you want to do this. How do we do it? Got to start by evaluating builder's remedy sites. So obviously your first task is going to be finding a jurisdiction that is not in compliance according to HCD. This becomes a little bit tricky because, as we'll say, as we'll discuss in a bit, compliance as determined by HCD is not necessarily compliance as determined by the courts. We'll get to that later. But one thing you certainly want to start with is target cities that do not have housing elements that are in compliance or that are currently under review by HCD. Your best case scenario is cities that have not even adopted a housing element. And there are some cities that have not even adopted a housing element. How can they have a substantially compliant housing element if they haven't even adopted one? Once your city adopts a housing element, it becomes a little bit trickier because if HCD declares the housing element is not in compliance, the city could theoretically still argue that it is compliant. And again, I'm going to get back to that point later. But I still think, you're in this yellow zone where it's arguable, but not certain. The harder case is where the jurisdiction currently has a housing element that's being reviewed by HCD. That's why I say here, target cities that are out of compliance and do not have housing elements currently under review. Because if your city's housing element is currently being reviewed by HCD, and then HCD 2 months from now says, yeah, you know what? That housing element is substantially compliant. The city will argue that its housing element was substantially compliant when it was adopted, right? All HCD did was confirm that our housing element was already compliant, right? So we didn't need HCD to stamp it for the element to become substantially compliant. It already was. So that's why you want to be careful with any city that has a housing element currently being reviewed by HCD, because if they stamp it approved, that may have a retroactive effect. But if the city's out of compliance and does not currently have a housing element being reviewed by HCD, the city is going to have a harder time making that argument. Of course, the hardest case for the builder's remedy is where HCD determines that the housing element is compliant. Even there, it is possible to argue that the housing element is not substantially compliant. I'll give you one example. This is a weird one. In Yorba Linda, the city adopted a housing element that HCD approved and determined was compliant. But then the city has a voter adopted initiative that any proposed housing element has to go to the voters. The voters rejected the housing element, right? So HCD certified it as compliant, but does Yorba Linda have a compliant housing element? I think that's kind of uncertain. So this is harder. And what this is all of what this is showing you is there are still a lot of questions about the builder's remedy, because again, I'm going to talk about this when we get more into the opportunities and risks. This law has not been used very much historically until very recently. So there's a lot we don't know about how courts are going to interpret some of the relevant language and how it's going to interpret the meaning of these various deadlines and of the determinations that HCD makes. All we can do is kind of make educated guesses and arguments about how we think things are going to go. So I would target cities either that don't have an adopted housing element, or again, that do not have housing elements currently being reviewed. And also look for cities that are likely to be out of compliance for at least a few months, because you need to take the time to prepare an application, which is what I'm going to get to next. Once you identify a jurisdiction that you think is a good target, the next thing you have to do is prepare an application. You're going to need some time for that. So you want to make sure that in the time that you're preparing your application, the city isn't going to suddenly get into compliance. So most cities that are out of compliance are likely to be out of compliance for a while, because under the new law, under the current law, most jurisdictions can't get into compliance until they complete a lengthy rezoning process. But this is just something that you want to keep your eye on. If your city is actively working on revising its housing element to submit to HCD, then you may want to sort of expedite your process of getting your application in before they're able to submit to HCD. You want to try to submit that before, again, HCD starts actively reviewing the draft housing element. Okay, so that leads us to the timing and application process. All right, so the sort of working theory right now and the way that most of the existing builder's remedy applications have gone is that applicants are using a new state law called SB 330 to take advantage of the builder's remedy. SB 330 is a process for filing a development application. That's all it is. It's a process. And what SB 330, the process that SB 330 creates, is it allows applicants to file what's called a preliminary application with very minimal information. And the idea here is that once you submit that preliminary application, it freezes the jurisdiction's development standards in place at that moment. So here's the theory. If you submit the SB 330 application while the city is out of compliance, then even if the city gets into compliance later, that won't matter, because by filing the SB 330 application, you have frozen the development standards at the moment that you applied, and you're entitled to proceed under the standards that were in place at that time. So that's why I say, as I said earlier, you want to try to get your application in while the city is out of compliance, because if you can do that with SB 330, it will freeze the sort of status quo at that moment. The SB 330 application is, like I said, relatively minimal. All of the standards are prescribed by state law, so it prevents cities from playing their normal game where they keep trying to ask you for more stuff and saying your application isn't complete. There's nothing like that. Under SB 330, there's a list that the state prescribes. As long as you submit those items that the state prescribes, the application is submitted and it freezes the development standards. Also, what's nice about SB 330 is the site plans and elevations they have to submit are not binding. They can change in terms of density or square footage by up to 20%. You can file something that is preliminary and freeze those development standards. And then you have, from that point, 180 days to file the full application with the more detailed information. Again, the theory is to file that SB 330 application while the city is out of compliance. That's kind of the recommended path. Okay, so that's kind of the basics of at least what we've seen in terms of how builders' remedies projects are being proposed, and this sort of what I think is probably the preferred way of doing it. Now let's talk about some of the risks involved and how to navigate them. As I kind of just alluded to earlier, there are a lot of unknowns about the builder's remedy. It is pretty untested. Although the law's been around for a while, there never really were any builder's remedy projects until very recently. And then we started seeing a whole bunch of them. But none of them have really been to court. And so there's a lot of unanswered questions. Let's talk about what some of those questions are. The big one, of course, is CEQA, the California Environmental Quality Act. The builder's remedy law does not provide a CEQA exemption. And so there are questions about how cities are going to try to use CEQA to, sort of stymie projects where they know they can't deny the project because of the builder's remedy. Are they going to use CEQA to delay the project forever? Right, that's one question. Are cities going to do that? Are they going to be able to do that? Are courts going to let them get away with it? Is the legislature going to step in and do something? I'm going to address that in a moment because I kind of want to just go through some of the risks and then talk about how to navigate them. So that's one big question. The other one I also just alluded to, which is the builder's remedy statute says that jurisdictions are subject to the builder's remedy if they do not have a substantially compliant housing element. But lawyers know that substantially compliant is not the same thing as compliant. It just means like, well, you're almost there. You're near there, right? So the court is not bound by HCD's determination. The court could, in theory, find that a jurisdiction's housing element is substantially compliant, even if HCD has not determined that it's compliant. That's one of the reasons why I recommend, your best case is if the city hasn't even adopted a housing element, how can it claim substantial compliance? Your next best is if its housing element isn't being reviewed by HCD, because then there's no question of that sort of retroactive thing I mentioned earlier. But that is a question, what does substantial compliance mean? And how strict are the courts going to be with jurisdictions about this? There's some older case law that suggests that courts don't consider substantial compliance to be a high burden. But there's also a theory, as I'll talk about in a bit, that the law has changed so much since the early 90s, I think, when this was last litigated, that those older cases are not really binding precedent anymore, considering how much the law has changed. There's also a question about the applicability of the builder's remedy in the coastal zone. There's, again, kind of questions about how you would harmonize the builder's remedy with the Coastal Zone Act. And there are a few other questions, but to my view, those are kind of the biggest ones. Let me talk about how to kind of navigate some of those, sort of the plus side, and then I'm going to talk more about how to navigate. I guess, if I had to litigate some of these questions in court, I think, a sort of sketch of how I might approach it is the HAA is an extremely pro-housing statute. Remember, the builder's remedy is part of the statute called the Housing Accountability Act. The law states that it must be interpreted and implemented in a manner to afford the fullest possible weight for the interest and approval and provision of housing. The law, as I mentioned before, places the burden of proof on the city. The applicant, as well as third-party housing organizations, are entitled to attorney's fees if they win. What this all means, I'm sorry if my head's in the way, is courts are supposed to resolve doubts in favor of housing. That means if there's some sort of question about how the law should be interpreted, what substantial compliance means, whether cities can use CEQA in a bad faith kind of a way, the law is supposed to be interpreted in a pro-housing fashion. And we definitely are seeing courts, after an initial period of being a little bit reluctant because historically cities have been very deferential to municipalities, courts in the last couple of years, the light bulb is really going on, and they're seeing that the legislature is serious and that they want these laws, the HAA in particular, to be interpreted in a pro-housing manner. So that's where I think there's definitely a reason for optimism. Okay, again, how to navigate some of these risks. Obviously, consult an attorney because you can see that some of these questions are quite complex. In terms of dealing with the CEQA issue, consider sites that qualify for a CEQA exemption, right? The infill exemption is probably a particularly good one because that takes me to my next point. Avoid projects that have significant environmental impacts. If you're choosing a site and a project that's not going to be adding significantly to vehicle miles traveled or have any other significant environmental impacts, that's going to make it harder for the city to try to use CEQA in a bad faith way to delay projects they know they can't deny. Like I said, the question that's out there that some folks are worried about is that jurisdictions are going to use CEQA to delay forever projects they know they can't deny, right? But that's going to be harder for jurisdictions to do if your project clearly qualifies for a CEQA exemption. And we're seeing at least early indications that the state isn't going to tolerate local jurisdictions that try to play games with CEQA to avoid compliance with the HAA. So for example, many of you I'm sure are familiar with what's happening in Huntington Beach, where the city essentially tried to declare that it was immune from all state housing laws, including the builder's remedy. And one of the grounds that that Huntington Beach stated was CEQA and CEQA impacts. Now, one might wonder if Huntington Beach is this sort of sanctuary from all state laws, why it's not also exempt from CEQA, but that's setting that aside. The Attorney General wrote the city a letter and said, wait a minute, you cannot use CEQA in a bad faith way to circumvent the builder's remedy. So that indicates that that's the position the Attorney General is going to take in litigation, that you can't use CEQA to circumvent the builder's remedy. And I think the courts are going to be, usually give some amount of deference to what the Attorney General has to say. So that's a good sign, although again, nothing's really certain. All right, but these are some good ways, I think, to deal with the potential CEQA issues. Next, fewer local regulatory constraints means lower risk. That means, in theory, you could use the builder's remedy statute in a jurisdiction to knock out 10 or 20 different development standards, right? Knock them all down. But the fewer zoning and general plan standards you want to deviate from, the less likely you're going to run into really, really angry local officials and residents. And so less likely they're going to fight you on some of these things. You want to try, if you can, given the uncertainty, to see if you can get the jurisdiction to be cooperative. And the jurisdiction's more likely to be cooperative if you're only asking for, say, 1 deviation from local development standards or 2 rather than 20. That leads to my last point, which is consider jurisdictions where elected officials will support the project. Now you might think, well, what's the point of the builder's remedy then? The whole point is to cram this down the throats of cities that don't want it. Well, here's the thing though. A lot of times the electeds like the project, but the neighbors don't, right? And there certainly are situations where the city even approves the project and then it's subject to a referendum from the neighbors. Well, if the jurisdiction's elected officials are willing to be cooperative, or if they're willing to not play games on the CEQA and give you the EIR or whatever other CEQA documentation that you need, then you have a much stronger position to get through the builder's remedy. And I think there's a very good argument. I mean, again, nothing's a slam dunk in this scenario, but a very good argument that builder's remedy projects are not subject to voter referenda, right? So if you can get the electeds to cooperate on processing the project in a reasonable time frame, to cooperate on the CEQA stuff, then this can help get around neighborhood opposition. And I think there's going to be jurisdictions where electeds are actually happy, maybe, to have the builder's remedy because it's a way they can say to their residents, look, our hands are tied. We'd love to deny this project, but Sacramento is telling us we have to do this, right? Because the electeds know that they need the housing and they know all of the consequences that can come from Sacramento if they don't, but they often have a hard time explaining that to their constituents. So the builder's remedy can be a way of helping electeds to deal with recalcitrant neighborhood opposition. So consider jurisdictions where elected officials will support the project. But again, I understand that's not always going to be the case. Sometimes you will have to deal with a hostile jurisdiction. But then keep in mind, you may run into some of these other obstacles where cities try to throw up other roadblocks to your project. Okay, so those are some of the tips on how to navigate some of these risks with the builder's remedy. Here's a couple of good resources. My friend Chris Elmendorf, who I'm sure anyone who knows anything about the builder's remedy knows Chris. He's written a really good primer on the builder's remedy. HCD has a memo, which I think is good to read, because anything HCD has to say about this, courts are likely to provide it with a significant amount of deference. So you can bet that anything HCD is saying, courts will take pretty seriously. And then my friends at YIMBY Law have also done a builder's remedy presentation, and their slides are available here. Finally, you should, my last slide, you should feel free to contact me by email or telephone if you want to talk more about builder's remedy, have questions about the presentation. Happy to talk with you about this stuff. It's very exciting and very interesting. And with that, I'm glad to take any questions or comments that you have.
Thank you, Ken. Yeah, I'll handle this Q&A thing. So for anyone that may have come in a little bit late, we will send these slides out, and this is being recorded, so it will be uploaded so everybody can view again. But let's get to the Q&As. So I just want to first apologize if I mispronounce anyone's name. Deep apologies. Please correct me if you can, in case that happens. But AJ says, the law states that if the project is revised by more than 20%, the preliminary application is no longer valid. Does this revision mean, one, revision by the developer, or two, revision forced by the city or court order, or is it either or both?
I can't imagine that the law would be interpreted to mean that the city can revise your project and now say, now you're not eligible for the preliminary application process anymore. That language is referring to when the developer changes the project. Because remember, like I said earlier, the preliminary application is preliminary and you're allowed to change the project. And the city's development standards are frozen in place at the time you file the preliminary. So what the legislature didn't want you to do is file your preliminary and then completely change the project and say, oh, this is the same project, I'm entitled to all the protections of state law. So I can't imagine that the law would be read any other way to say that this applies when the applicant changes the project. Right? Like I said, if the city could just say, we're changing your project and therefore you're not eligible for the vested rights, it would totally defeat the law. So I think the answer to your question is one. It's when the developer revises the project.
Thank you. Brian asks, is builder's remedy allowed in coastal zones?
Yeah, I mentioned this was one of the questions I raised earlier. That's not 100% clear. And this is something that might have to be resolved through litigation. As I said earlier, I kind of hinted how I would argue this one, right? Right here, the HA is an extremely pro-housing statute. It has to be interpreted to afford the fullest possible weight to the interest of housing. There's extensive findings of fact in the law about the nature and extent of California's housing crisis. And the reality is, if the HAA did not apply in the coastal zone, because keep in mind, this would not just apply to the builder's remedy, but the whole Housing Accountability Act, right? If the Housing Accountability Act does not apply in the coastal zone, that's the most expensive area in the state where the housing crisis is most severe. It can't possibly be the case that the legislature was so super serious about housing, but they didn't intend for the law to apply in the place where the housing crisis is most severe. So I think the courts are going to have to figure out how to reconcile the Housing Accountability Act with the Coastal Zone Act, rather than saying the Coastal Zone Act trumps the HAA. I mean, that would be, a very unfortunate interpretation. But as I said, that has not been decided yet. So that's a question. And so certainly, if you're looking at sites outside the coastal zone, you can maybe rest a little bit more easy than if it's in the coastal zone, because in the coastal zone, you are still going to have that question. But like I said, I mean, I think that's going to have to be argued. And I think based on what I have here, that courts really should resolve that question in favor of housing. And the question is whether they will. And if they don't, the legislature might actually step in and revise the law. I think that's also a possibility. We're seeing the legislature and the governor taking housing more seriously. They're embarrassed by this Berkeley CEQA decision that we saw a couple of weeks ago. And I think that could lead to some legislative reform. So that is an open question. But I think there's a solid argument that the HAA should be interpreted to be reconciled with the Coastal Zone Act and that it does apply in the coastal zone.
So I'm not going to skip these next two questions. So please don't panic, anybody. But Daniel asked a question that was sort of related. So he actually asked, how far inland do the coastal zones extend? If you know that.
Yeah, I don't have that information right on hand. I know that there's the law has sort of a rule of thumb about what's considered the coastal zone. But you can probably find that in the California Coastal Commission website. I'm sure they have a map of what's considered the coastal zone. That's probably pretty easy to find.
Patricia asks, how do you view cities that have self-certified?
Okay, good. Yeah, so Patricia is really paying attention to this builder's remedy stuff, because this is one of those nuanced questions that keeps coming up. This goes back to the question of what substantial compliance means here. Remember that it's not, the court isn't necessarily going to be bound by what HCD says. So if a jurisdiction says, well, we've declared ourselves in compliance, a court could theoretically say, well, that's substantial compliance. And again, I've said there is some older case law that suggests the burden isn't very high. But I doubt that that is going to fly. And HCD had also recently issued a memo saying that they disagree that a city can self-certify. Because again, this would really undermine the whole idea of the builder's remedy if a city could just declare itself compliant. But a court has a responsibility to determine if the jurisdiction is actually compliant, and especially if the expert agency says they're not, and courts will also usually give a lot of deference to the state housing agency. I think it's going to be difficult for cities to make that argument. But certainly they're better positioned self-certifying, I guess, than if they don't self-certify, because then they have no certification from anyone of being compliant. So maybe they're thinking, well, this at least is sort of an outside chance. But no, I don't think it's a great argument, but it does illustrate that there's still a lot of questions about what substantial compliance means.
That's an interesting one. Catherine asks, what do you think will be the outcome for Huntington Beach?
This is one I feel pretty confident predicting that they are going to lose in a very embarrassing fashion. There's just no legal merit to any of the arguments that Huntington Beach is making. The charter city type arguments, they've already litigated and lost numerous times. Many other cities have already litigated the RENA question and lost that too. So I think there's also a timing question. I think Huntington Beach is too late to bring this lawsuit because it should have been brought a year ago. So I just, I never like to say anything with any certainty because there's so much uncertainty in this area. But I don't think Huntington Beach has a very good chance of prevailing in their lawsuit. They already lost their initial motion for a temporary restraining order, and the judge didn't seem too impressed with the city's case. So I would certainly bet on the state if I were betting on this litigation.
Kurt says, I know these things take a long time, but what's your guess as to how long these initial builder's remedy projects take to actually get built?
Well, that all depends on the city's processing schedule. So this law, the builder's remedy doesn't provide any kind of streamlining, right? I think if you pair it with a law like SB 35 that provides streamlining, then you can make the process go faster, right? Under SB 35, the city has to process the project in an expedited way. There is no expediting under the builder's remedy, which means you'd have to go through the normal process of trying to use CEQA to make the city act on its CEQA deadlines. And courts traditionally have been reluctant to force cities to act quickly on their CEQA deadlines. So there's no reason to think that cities are going to process these any more quickly than they would other projects. But if they're moving unduly slowly, then there are some techniques that can be used, including pushing them with CEQA, trying to involve HCD. So this is, we've had some success doing this with some cities where we've gotten to HCD and said, hey, this city is not processing projects on the timeline that CEQA requires. And HCD has written letters to some cities saying, hey, your city, you're not processing your projects in accordance with your CEQA timeframes. That can affect whether you're going to get your housing element certified. So there are some techniques that can be used to try to push cities to move a little bit faster. But like I said, builder's remedy does not include any kind of streamlining or strict time frame for cities to process the project.
Yeah, and you said you'd want to pair it with SB 35, and I have to mention that that if you're interested at all in knowing about and using SB 35 as a pair with this, definitely look out and track SP 423, because that's going to permanently extend SB 35's abilities. So look out for that, folks. And then AJ asks, what about if the court orders the change that results in more than 20% change in the plans? Do we lose the vested rights by preliminary application?
If the court were to order a change, I don't know how. That's a very specific question, and I feel like I'd want to know more about the specifics. I mean, do you have an actual court order ordering you to change your project? I mean, if so, I'd be interested to see what the court order says and respond to that specifically. But I'm having a hard time envisioning, hypothetically, a situation where a court would order a change to the project. I mean, the court can find that the CEQA paperwork wasn't done properly and send it back for more CEQA review. But I'm not sure how a court would order a change to the project that would adjust the square footage or density by more than 20%. So I have a hard time answering that one in the abstract.
And then he follows up, and AJ says a court could order that a certain area is not valid for building. I don't know if that's a question or.
Oh, so you mean like if so? Well, again, it's hard to answer that hypothetically, because that wouldn't necessarily be ordering a change to the project, which, right? Even if a court were to find that, well, I mean, in that case, then you'd be doing a new application with a new project, I guess, right? And then it would be a whole new project. But again, I'm having a hard time answering that one hypothetically, because I don't see how that would happen, that a court would order a change to 20% of the project, or would order a change that would result in the losing of the vested rights. But certainly I could imagine something happens if the court upholds the denial of a project, and then you have to change the project to try to get an approval. Then if it's a new project, then you would lose the protection of the preliminary application. But that would only be after you've had the project denied. So again, I'm struggling a little bit with seeing what the hypothetical is. But again, I had more specifics maybe.
Yeah, and he just says a certain part of the lot could be determined by the court not to be buildable, but the rest of the area is buildable.
Yeah. Well, I think this is one of those questions where I'd be happy to talk with the individual offline about this, because I feel like it's very specific and it might help to learn more. It sounds like the questioner might have a specific project in mind. So I'm certainly happy to speak with them if they want to discuss that in more detail. That might be better than trying to answer it sort of, in the abstract.
So moving forward, Garrett asks or says, La Cañada self-certified their element and backdated to a previous draft. And now they say we are not subject to the builder's remedy while submitting their third draft. Their previous draft was the second, excuse me. And now they're saying we're not subject to the builder's remedy while submitting their third draft. So I think you said something earlier about how it's best to use builder's remedy when the draft is not being reviewed, right? Is that sort of
right? Because if they've submitted it to HCD, I guess it's possible that HCD would say, yeah, this is okay. Again, I'm a little skeptical about self-certification. I think cities are just trying to position themselves for litigation and also maybe scare off applicants by saying, we're going to fight you if you try to file a builder's remedy application. But I'm a little bit skeptical, and nothing's for sure, but I'm a little bit skeptical that the self-certification argument is going to work if cities actually have to litigate it. But if the housing element is pending before HCD, it's possible, like I said, that it will get approved. But certainly one thing that I'd want to look at for any jurisdiction that's housing element is being considered by HCD is, how realistic is the housing element in terms of what the jurisdiction's planning to do? Because if the jurisdiction, for example, isn't proposing any real rezonings, then HCD probably isn't going to be approving the housing. And I don't know anything specifically about La Cañada's housing element, but I know it's a jurisdiction that traditionally has been very resistant to housing. So I'd be surprised if their housing element is one that really commits to substantial rezoning. But I'd have to look at the housing element to see how likely I think it is that HCD will find it to be compliant.
So that's all the questions we have in the Q&A right now. I definitely want to give folks like another minute or so to put any comments or questions or anything in the Q&A or in the chat. I'm monitoring both. So I mean, if there's anything else, like please feel free to get that in there. But I guess I'm curious, Ken, like, these are still all relatively new, right? Like the use of builder's remedy is still new. And I think the last time in January, I think you said that there were so few of them that it's really hard to get into how successful really it can be, just because we don't have anything clear to look at it. Am I remembering that correctly?
Right.
Okay.
So, I mean, there's definitely more. I mean, there's, I don't know how many, I haven't been keeping track, but I know that last time, at least in Orange County where I live, there were only like 3, and now there's at least 25, I think, Orange County builder's remedy projects. But we still don't really know much more because it takes a long time for these things to get litigated, if they ever do get litigated. So we're not going to get anything really definitive from the courts for a while. We may get some more guidance from the legislature or from HCD. And the governor's been a little bit more aggressive and may continue to be. And so I think it's more likely we're going to get guidance from HCD, or the governor's office, or the legislature than from the courts. The courts are going to be, at least another year or more until we really get any really firm guidance from the courts about the builder's remedy law.
We've got another couple of questions, and I just want to be mindful. We do have about 5 minutes, and we want to respect everyone's time. So if you've got anything else, please feel free to get that in there now so we can get it answered. But Garrett says, and Kurt, I'm going to come back to you just so you know. But Garrett says, can you change your project within 20%, more or less, in any way that would put your vested rights in danger?
Well, the law just says that you lose the rights if you deviate by the 20%. It doesn't say anything. So I mean, if I were just reading the face of the law, I'd say my argument would be, well, this is what the law says. It's less than 20%. It doesn't count. But I would definitely advise anybody who's thinking about changing their project, or they're thinking, well, I might have to change something. Again, talk with your attorney about that, because you want to kind of talk through those things and what some of the risks are. I mean, I definitely think the more radically you're changing the project, then maybe the more likely the city will fight you on it. But again, I think the law is pretty clear on it. But again, that hasn't been litigated either. So I guess it's possible, if you're like changing it from a 1-story project to a 10-story project, that you're gonna have some issues with the city maybe. But that really depends, I think, on the specifics.
And then Kurt asks, and we might make this the last question unless someone gets in there real quick. But as he asks, what's your favorite builder's remedy project that you're aware of?
Oh, I don't know that I have a favorite. I mean, I'm certainly appreciative of the project in Redondo Beach that kicked this whole thing off, because builder's remedy is something that I and a few others, like Chris most famously, have been thinking about for a while. And kind of wondering if anyone was really going to take advantage of it to put some teeth into some of these housing element requirements. And so that Redondo Beach project really, I think, turned the light bulb on for a lot of people that this was an opportunity. So I guess if I had to pick a favorite, it would be that one.
Nice. Okay. So yeah, I think that's all the questions. Thank you so much, Ken. Like, not only for doing this, but for doing an encore presentation of it. And so AJ says he filed his builder's remedy project on June 24th, 2022. And I think maybe he's speaking to how long it takes for some of that stuff to get litigated, like you said. But AJ, I do recommend that if you do have any other questions, you reach out to Ken. Because yeah, like he Ken called it, it seems like you have like a very specific project. So yeah, reach out to Ken, let him know if you have questions, and hopefully we can get any kind of clarity for you that you might need. But yeah, thank you, Ken. And all of you that are watching, this one, unfortunately, is not part of our pro housing leadership course. But Abundant Housing LA does have a pro housing leadership course that will help you learn a lot about housing from parcel to architecture. So please contact me. I put my email address in the chat, joshua@abundanthousingle.org. Great academics and experts do various presentations on various housing topics. It's recorded. We have slides, and we're still enrolling folks. And there's lots of good discounts and fee waivers. So reach out to me if you're interested. Thank you, Ken. So grateful for you. And I hope everybody has a really, really, really good night.
Thank you, Josh. It's great to be here. Appreciate everyone's time and your questions. Good to be here.
Thank you. Have a good night, all.